Hello and welcome to the Arbitration Conversation. So in this episode, this is going to be really fun. We're going to have a discussion with the American Arbitration Association arbitrator, Katherine Haennicke. Now, Katherine has done a wide range of arbitrations with the AAA, including employment and consumer, and a lot of different areas that involve pro se litigants. So what I wanted to talk about today is a really hot issue, super important issue. As an arbitrator, how do you manage the situation with pro se litigants? So thank you, Katherine, for taking time with us today.
Thank you, Amy. I greatly appreciate being able to have this conversation. I find arbitrations are a really meaningful way in order to resolve disputes, and I think they provide a really great accessible way for people who are not lawyers to be able to be heard on their issues and get resolution. So it is very difficult. You know, our general legal system can be hard to navigate, and arbitration I find to be, you know, it still has a lot of rules that you have to follow, but I think it's a much more understandable way for a lot of litigants who, again, aren't as steeped in the law as many of us, in order to be able to participate and get their disputes heard. So, you know, as an arbitrator, I really do want to strike that balance and make sure that the pro se litigant can come, either have their case be heard or defend themselves, but in a way that they can communicate, because they're not going to have all this magical legal ease, and they're not necessarily going to know all the elements of a particular claim. So as an arbitrator, I really try, especially initially, to try and help set up some of what those expectations are and give them an understanding of what the process is. So when I have my very first preliminary hearing call, I always make sure to explain, this is what the call is going to entail. After this call, this is what the next steps are going to be. This is ultimately where we're going to be going. So they have an understanding of the process. But then I also lead them. The American Arbitration Association has an amazing pro se site that really helps and has a bunch of tools in order to say, when you go to hearing, here's how you present your case. And so in order for me to be more effective and to have a really effective arbitration process as a whole, that's a really great tool and a site for all pro se litigants to go to, so that they can then meaningfully participate within the arbitration process itself.
You know, that's so important, because I think all too often we just kind of jump to the conclusion that arbitration is going to be bad for consumers or employees. But really, oftentimes, actually, it can be beneficial for a pro se litigant. I mean, you can save the cost right off the bat of not having an attorney, right? So, especially for a lot of the pro se, you know, they don't have attorneys, that you can save that money. But what are some of the challenges? What challenges would you say you face as an arbitrator when you do have pro se litigants?
You know, so some of the challenges are definitely trying to make sure that the litigant understands what they have to prove. You know, I'll use, for instance, if a consumer files a cause of action against another party. They may say that let's say it's fraud. They may not understand what they have to prove in order to recover on fraud. And you can't get around those. Just even though it is arbitration, they still have to make sure that they prove enough in order to get, you know, say, here's what my injuries are and here's the damages. You can't get around that. The one nice thing with arbitration is you can get around, you know, the pleading requirements are much more liberal according to the rules. So they don't necessarily have to require the specificity or the particularity. But again, that also then doesn't help them understand what they actually have to prove. Even if it's a breach of contract, sometimes that's a little easier, because we all understand we had a contract. You said you would do this, I said I would do this, and the money was going to be paid, or services rendered or whatever. So sometimes that's a little easier, but again, the challenges initially is really helping the pro se litigant understand what their burden is. On the flip side, if they're a defendant, you know, and they say, well, I didn't do anything wrong, how do you can't tell them, well, this is how you prove what you didn't do, or this is how you prove your defense, or here's what your defenses are. I can't do that as an arbitrator. And so that's a big challenge.
Yeah, I mean, as we're talking and I'm thinking about this, I mean, that brings me to the next question, which is, how do you strike the right balance? Because on the one hand, you want to provide information to the pro se litigant about how, what elements they need, for example, to prove fraud, as you were saying, but then you don't want to appear as though you're representing them or you're kind of crossing that line and no longer a neutral arbitrator. So how do you strike that balance?
Definitely on a case-by-case basis. But again, one nice thing about arbitration is, as an arbitrator, I have a lot more leeway, especially in the hearing. And so, leading up to the hearing, I constantly refer the parties to that pro se litigation site, and because it does provide so much information. But once I get to the actual hearing, a lot of times it's just pro se litigants certainly want to be heard. And I will ask a lot of questions. Again, as an arbitrator, we are provided that opportunity. And we don't have to go through quite the formality as you would in a court. And so, but to be fair, I ask a lot of questions of both sides. So I want to make sure that I'm not trying to prove their case, but it's really more of a conversation. What do you think is important to you? What do you want me to know? What are you trying to convey? So like, I ask a lot of very open-ended questions in order to, again, have that conversation with the litigant so that they can be heard. And I provide the same leeway to the other side, even if they are represented by counsel. I give them a lot of leeway too, to kind of try and shed the formalities. Ironically, I find it interesting that in arbitrations, some of the lawyers have a very difficult time because they stick to the formalities, because that's what we're trained to do, and that's what we're used to. So I know in a lot of the proceedings for me, I would really, I would encourage people certainly to consider adjusting to what the hearing is. And, even for parties represented by counsel, maybe consider shedding some of those formalities and use this as a way to have that conversation to bring out the truth of the matter of what really happened and what the results should be, rather than sticking to, certain types of, direct questions or cross-examination or, foundation for evidence. But again, take arbitration for what it is.
Yeah, I mean, I'm hearing a lot of really good tips and tactics and sort of tools, along with, considering the hearing and also the needs of the situation. Are there any other sort of tips and tools that you would recommend, especially if you are counsel and you're involved in this arbitration, right? So if you are counsel for the party that does have representation and the other side does not have representation, are there any particular insights you would provide to those attorneys?
Don't take that for granted. Just because the other side isn't represented by counsel doesn't mean it's a slam dunk. I think sometimes people underestimate, be like, we've got this. And you'd be surprised how often pro se litigants can really put together a case. I had one particular matter involved. Obviously, I can't discuss names of parties or anything like that. But the general issue was, it was a consumer case, generally involving the concept of breach of contract. That pro se litigant came in, had all of his exhibits laid out. He had copies for everybody. He walked through everything. I had a few questions, but to be fair, I honestly didn't have to lead through much. And he proved his case so well. And the other side was taken aback. And they actually had to take a recess in order to kind of retool their entire case, because I think they kind of took it for granted that there was a pro se litigant or a pro se claimant. So I think that would definitely be tip number one, is prepare accordingly. But again, don't be afraid to shed the formalities that we know from court proceedings.
Yeah. Well, and kind of talking about formalities and also talking about the situation we live in now with COVID-19 and sort of not the ability to be in person. Have you seen a lot of use of video hearings, and especially in these kind of pro se cases?
Oh, yes. In fact, we've had several. So even leading up to COVID, I would allow for telephonic hearings because, especially with arbitrations, parties could be all over the nation. And so I would allow people to appear telephonically. But now in light of COVID, we are doing a lot more video conferencing via various platforms. And I think both sides need to be flexible and understand and just let the arbitrator help lead and rely on the arbitrator a little bit more for those. Arbitrators have to jump in and embrace it. And it certainly is taxing our own abilities as arbitrators to lead these. It's certainly leading to interesting times. But as long as the parties are willing and open to say, okay, this is a new day and age. We have, unfortunately, a world pandemic going on currently. But even after this pandemic, I think this will still provide an amazing opportunity for people.
Oh, yeah.
To be able to be heard timely, and you could be anywhere.
100%. I mean, I believe it lowers the barriers to entry for a lot of pro se litigants because it makes it way cheaper if you don't have to travel and you don't have to worry about time off of work or whatever else might be involved if you have to actually go to an in-person hearing. Have you run into any issues though where you have to help balance technology? So you might have a party that has more facility with the technology or is more used to it or more comfortable with the technology. Have you run into that as an arbitrator?
Oh, definitely. That certainly has been a challenge. I will say, once parties get into it, especially pro se litigants, they actually are a little bit more comfortable because they're in their own homes usually. And so, once you come to a formal hearing, people tend to tense up. But pro se litigants are actually, I think, finding this a little bit, once they can get into it, a little bit easier, and they calm down a little bit. But from a technology perspective, I am not an IT professional at any stretch. And certainly there are a lot of times that you have to troubleshoot. But again, as long as you as an arbitrator can rely on your skills, think outside the box. And you know what? Sometimes, all right, platform is going to go down, or there was a time where there was an electrical vault fire in my neighborhood and I lost all power. And I was like, all right, let's do this via phone. So you just got to adapt to the situation. And be willing, or rescheduling or whatever. So, and there are times, unfortunately, we have some pro se litigants who don't have access to technology. So now I have to maybe go to a library in order to be able to do this, or, via their phones, which is a challenge. So certainly, I will say for the American Arbitration Association, they do provide some assistance with that in order to help lead them through that. And for arbitrators, they provide a lot of training and opportunities too. So I think it is a challenge right now because a lot of people aren't used to it and haven't been as open to it. But I think going forward, people will just adapt and then they'll start getting used to it. And I think it's going to be a great medium. It's going to be great.
Yeah, I have to say, well, I've been writing about ODR, online dispute resolution, for many, many years. And I think COVID-19 has done more for ODR than anything else as it moves people into sort of a new normal. But especially I do think your point about pro se litigants feeling more comfortable at home, it's true of most people, right? I mean, it's less stressful when you can do something from your home instead of sort of having to go before anyone. Even if you're not sort of a scary judge in a black robe, it doesn't matter. I mean, you're still the arbitrator, right? And that always comes with a certain amount of formality. Yeah. So are there any other...
I was going to say, on your point, I remember back when I was in law school, quite some time ago, but back then, and I think it was in 1999, I actually wrote an article because I took some mediation classes, and I wrote an article with somebody. It was a mediation and arbitration class. And I came up with the idea of online arbitrations where people submitted their documents online and then the arbitrator would review them and review the documents, opening the briefs and everything. And then it would be faster, more efficient, and cheaper in order to do that. I got laughed at so hard and people were like, this will never work. How would this work? And I actually had created like a little website and all that as part of the project that I was working on. If only I had taken it back then and ran with it.
I know. Well, actually, the first article, well, no, there were some other ones, but I wrote, it was way back at that same time, I wrote this article, Drive-Through Arbitration in the Digital Age. And it was this idea of online arbitration and even bringing in the idea of Second Life. And you could have avatars who are arbitrating for you. So there's a lot of...
We could have like a SimCity arbitration.
Yeah, sure, why not? Let's make it fun. Well, this has been so much fun just talking to you all day. I could just keep talking, but I promised I wouldn't take up your whole afternoon. So thank you, Katherine, for taking this time with us. Really good tips and really good information about how to address pro se litigants when you are the arbitrator. So thank you for taking the time with us today.
Thank you, Amy. I greatly appreciate the time. Arbitration is very near and dear to me, as I've mentioned. And again, I think it's such a great medium for people who may not otherwise have access to resolve their claims. So I fully support it. I fully support online mediums. So thank you again for allowing time for us to have this chat. I appreciate it.
Thank